Good morning. Welcome to our live webinar where the topic is child custody, child maintenance and divorce live Q&A. My name is Advocate Mohammed Abduroaf and I'll be hosting this short Q&A where you're welcome to post any questions you may have on the topic of child custody, child maintenance and divorce. The way you do that is via the Facebook platform. If you are not on the Advocate Mohammed Abduroaf Facebook page, please type into your browser www.abduroaf.co.za/live. It will redirect to the correct Facebook page. Yesterday we were discussing on the issue concerning child maintenance. There were questions posed and we answered all of them. If you have a specific question, please post it live on Facebook Live and we will try to assist you by answering those questions and obviously giving you some advice on how to handle your problem. So if you have a problem regarding child custody, child maintenance and divorce, please feel free to post it. I am keeping an eye on the Facebook page and any questions that are coming in, I will try my best to answer it. Yesterday we discussed child maintenance and child custody in a bit of detail. We did not touch too much on divorce because these webinars are intended to be very short at about 15 to 20 minutes long. I'll just recap on the issue concerning child maintenance because we are dealing with the pandemic, it being lockdown. Many people lost their jobs. People are earning much less than they are used to earning, which is obviously concerning and the reality. And if parents are earning less, it automatically means that their maintenance obligation may be different. And the reason why I'm saying may, if you are earning less, it doesn't mean that you cannot necessarily afford to pay the required child maintenance. You might own properties, you might have assets that you can sell that can be used to pay the child maintenance. You might have a lot of savings available which you accumulated over the years and can be used to pay the child maintenance. So it does not by default mean that you lost your job or you are earning less, that you are now entitled to pay less child maintenance. Everything will have to be looked at: your income, your assets, your liabilities, and so on. And then the court can decide whether or not there are any merits for a reduction in child maintenance. But obviously, with the lockdown and many months have passed, circumstances most probably have changed. The child no longer attends certain extramural activities. The parents are using less money for petrol, or maybe more money for petrol. The parents are maybe using much more money now for electricity, water, rates, etc. And furthermore, kids are most probably eating much more now that they are at home. It depends on the circumstances, but obviously things are different. It's lockdown and things will have to be re-looked at. So my advice yesterday on the webinar, if you did not watch it, please just go one video back on the Facebook pages, the Our Lawyer, Private Legal, Abduroaf and so on. And you can see the video which I posted, or the live webinar that took place yesterday. And we dealt in quite detail on the aspect regarding someone losing their job during the national lockdown. My conclusion basically was, if you are eating during the lockdown, you have clothes on your body, you have money for some type of entertainment, for internet, WhatsApp, and so on. Do not expect the court to be lenient on you, where you're saying, it's okay for me to have food on the table, it's okay for me to eat, it is fine for me to have a bit of entertainment and so on, but my child being cared for by the other parent, he or she can suffer, but I will be looked at or looked after. I think that's totally unacceptable. If you expect to have a meal for breakfast, lunch, or supper, you must make sure that your child, even if you do not see that child or have contact with the child, you must ensure that your child has a meal to eat. If it means that you should cut your meal in half and give the other half to the child, then that's what you must do. So no leniency regarding child maintenance. However, if you have lost your job and you really cannot afford to pay the child maintenance, we have to look at the matter again. Sell your property, sell your cell phone, get a cheaper cell phone, um, sell your car, sell your property. If you own a house and you cannot afford to pay the child maintenance, sell the house and make sure that your child has food to eat. If it means that in a year's time or soon after you have to take out another bond, then that's what you must do in order for your child to survive. So there is no leniency. It does not mean that you lost your job and it's COVID-19 automatically the child should suffer. You still have a legal obligation to sell your assets. If you really have no assets and you really have no income whatsoever, make a plan, get a job, earn R5 a day, R10 a day, and half that money goes to the child. But please make a plan. There's no leniency regarding non-compliance with maintenance orders during the national lockdown period. We can obviously accommodate. That's what we must do, considering all the factors. So if a child used to receive an amount of, let's say, I'm using round figures here, 100 Rand per month, and all that you can now afford this month is 60 Rand because you sold your cell phone. Wonderful, pay the 60 Rand. And at the same time, make an application to the maintenance court for a reduction where the court can look at this whole matter holistically. So I think we dealt with the issue regarding child maintenance. Child custody during the national lockdown, contentious issue. It's not that easy to advise people regarding child custody matters, whereby, firstly, we had a problem at the start of the lockdown where the minister said no movement of children, meaning if the child or children were at parents' A home just a minute before the national lockdown came into effect, it meant the child should have remained there. Later on, the regulations changed. It stated that you can move children around if there is a valid court order or a parental rights and responsibilities agreement, a parenting plan registered at the office of the family advocate. Then they became a bit more reasonable in my view and logical, where the law changed or the regulation changed and said that you can move the children as long as there's a birth certificate or proof of paternity or maternity, or as the case may be. So things have developed, but as we are sitting now, kids can obviously move from one parent to another parent. That does not automatically mean there was a right to have contact with a child. So if the other parent refused contact, there's not much you could have done unless you went to the court and the court could have enforced it. Then there was another problem regarding interprovincial movement of people. Big challenge. That was one of the questions we got yesterday. If a parent lives in Cape Town and the other parent lives in Johannesburg, and you're entitled to have contact with the child during the December holidays, June holidays, or holidays that fell during the lockdown period, problems would have obviously arose. Then what happens after that? My advice was, you need to look at the court order. If the court order specifically stipulated that contact must be during those specific periods, and that's it. And unfortunately, during the lockdown, because of the national lockdown, you could not exercise contact. Although the order said you should exercise contact during that specific period, but it could not because of the lockdown, and there was no fault on either of the parties. Unfortunately, my view on that issue is that the court order stands unless one of the parties takes it to the court and they try to, change the court order. Obviously, the parents can come to some type of amicable arrangement. Please put it in writing. You do not want to have problems tomorrow when one parent takes you to the police station and lays a complaint against you. Okay, the questions are now coming in. Wonderful. Please feel free to share this video and pose whatever questions you have. I'll deal with the first one. Is there something wrong with me paying 700 Rand for a 3-year-old son? So the Pacific person posed the question, which I get a lot: what is a fair amount of maintenance? I would not say there's anything wrong with that. I would say there would be something wrong with that if the child, for argument's sake, costs 700 Rand per month, the mother earns 600 Rand per month, and you earn 3,000 Rand per month, for argument's sake, and you are paying a small percentage of the child's expenses, although the child actually requires maybe 1,000 Rand per month. So where I'm going to with this specific answer, and I'm trying to be general here. It all depends on the needs of the child. if the child requires X amount of money. If the child only requires every month 400 Rand per month, you should not pay more than 400 Rand per month. If you decide to pay everything, you shouldn't pay 600 Rand per month, because then it means that 200 Rand per month goes to the other parent. If you want to, you're welcome to do so. I'm not stopping anybody from doing that. But legally, your obligation is towards the child. And obviously, you have to pay a reasonable amount of maintenance, considering your income, your expenditure, the mother's income, the mother's expenditure, and also the reasonable expenditures of the child. So that's what we look at first, the child's expenditure, and then we look at the parents, and they should contribute reasonably. So there's nothing wrong with 700 per month for a 3-year-old son. However, there will be something wrong if the person who's supposed to pay the child maintenance earns much more than the other parent, and the child costs a lot of money, and he or she only contributes 700 per month. But if that's a reasonable amount of money to pay under the circumstances, there's nothing wrong with that. Even 500 Rand, 200 Rand, depending upon the circumstances of the case. If, for argument's sake, let's use the scenario of mother and father. If the mother is wealthy, she has a lot of money, a lot of property, a lot of assets. The child is 2 years old. The child most probably costs, let's say, 2,000-3,000 per month. I'm using simple figures here again. The father does not earn so much money. He's a normal salary earner. He earns, for argument's sake, 5,000-10,000 Rand per month. And the mother earns 50, 60, 70,000 Rand per month, has a lot of assets. Under those circumstances, there will be nothing wrong for the father just to pay 1,000 Rand per month maintenance, or 500 Rand per month maintenance, seeing that the mother, proportionately, she owns much more than the father, or she earns much more. Second question. Hi, advocate, please explain why are moms getting primary residency more often as family advocates and court? At family advocates and court. So I presume that the courts are not, that according to this specific person's comment, he or she presumes that the court has a preferences for mothers to have primary care. Let's go take it one step back. So we all know that when a child is born, there's a tendency or a stereotype that the mother will be the best person to care for the child, and most probably that could be right under most circumstances. Child is born, child being breastfed, and so on. Father goes to work. The father is not needed so much at that first few months period. I'm just speaking generally here. I do not believe that there should be a preference for any parent at a certain age for a child. If the mother was the one that generally cared for the child from birth, she was the one that was awake during the evenings, fed the child, cared for the child, and so on. If that was the case, and now there's a dispute regarding who would be best capable of caring for the child. Obviously, the mother might win this one because the child was always being cared for by the mother. She knows how to care for the child, and so on. And it also depends on the age of the child. But let's deal with a different scenario. Yes, the mother cared for the child from the word go. When the child was at 4, 5, 6, 7 years old, the child went to daycare. Dad picks the child up from daycare. Mom is at home, is at work. When the child comes back from daycare, someone else looks after the child, and so on. So where I'm going to is that both parents cared for the child equally. When the child is ill, the mother would be the one that sometimes wakes up during the evenings, depending on how her schedule is the next day. If she has an important meeting the next day, then the father will be the one that wakes up and cares for the child when the child is sick or requires attention during the evenings. The father takes the child to school some days, the mother takes the child to school some days. Extramural activities, they share. So both parents are actually involved in the child's lives equally. Under those circumstances, there should not necessarily be a preference. The preference should basically be what is best for the child. Then we look at external factors, for example. One such example would be which parent will be living closer to the child's school. Now that would make more sense for the child to live with that specific parent should they have separated, and so on. You have to look at the matter holistically and determine what is best for the child under the circumstances. So there should not be a preference for a mother by default to have custody over a child. Everything has to be looked at. I would argue most probably, depending upon the age of the child, if the child is very, very young and the mother's caring for the child, obviously there will be a preference for that. But not always the case. I mean, if the mother is on drugs, she abuses the child, she has a mental problem, and so on, then there's a case for the father. But the question is, can the father care for the child? So it does not mean if one parent cannot care for the child, by default the other parent is capable and automatically has the capability of caring for the child. That is not the fact. So the specific person that commented over here, I would say It should not be the case. There should not be a preference for mother or father. We should look at what's best for the child, and if the mother can care for the child better, yes, the mother must have custody. If the father can care for the child better, the father should have custody. And in the family advocacy report, and in the social workers report, and in the court's judgment, the court should explain why they gave custody to the mother or to the father. Next question. What if the father is not paying maintenance, claiming huge reduction in his salary due to lockdown, but he is wearing designer clothes, earning out, or sorry, I think they could be eating out, etc. He may say that the clothes are bought for him by his girlfriend, parents, friends, but I still don't think that is acceptable if the school fees and maintenance hasn't been paid. Your views, how to argue this to the magistrate. There will be a counter argument for every argument that you bring. My view on the matter is, under those circumstances, if the clothing are being purchased by his girlfriend, by his mom, and so on, those are obviously gifts, but those also become assets. Then I would say you must sell that specific clothing and use that money for child maintenance. As I keep on saying, and people do not understand this, child maintenance is not determined upon a person's salary. You look at a person's assets as well, his earning capacity as well, and so on. So for this specific person, I would say subpoena his bank statements. Let's have a look at his bank statements. Let's see what's happening through his bank accounts. Who's paying for these restaurants? Who's paying for these specific, lavish expenditure? If he is getting designer clothing, I mean, how can a father, and this is a father, we're referring to a father over here, how can a father wear expensive designer clothing worth thousands of rands, and at the same time knowing that his or her child does not have food or adequate food on the table, and so on? I would also magistrate clearly that specific assets must be sold. If the jeans is worth 2,000 rand, it must be sold for 50 rand, and the 50 rand must be used as child maintenance. There are clothing, and the person has clothing, and the person has other clothing which a person can wear, and all the designer clothes must be sold. The courts must take a robust decision. If the magistrate does not take a robust decision, then they are failing the system. You are welcome to wear the most designer clothing. You're welcome to drive a Ferrari, Porsche, whatever car you want to drive. You're welcome to travel the world as a parent, on condition that you are paying adequate maintenance to your child. So if your child is being looked after, child is in a good school, under the circumstances, of course, eating and so on, you can do whatever you want to with your money. But if your child is not being looked after and cared for, your money becomes the child's money, and the court must come in and ensure that you do something proper. And in this case, sell the designer clothing and let that money be used as child maintenance. If you have any further questions, anybody watching this video, this live video, please feel free to post it as other people are doing. And if you are watching it later, please share this. People might find it useful. Next question. If you marry to someone else after a divorce, does a new wife have to pay child maintenance to the dad's child? I get a question a lot. So what happens is, someone divorced, so the husband divorced his wife, or vice versa, but they are divorced. He remarries. He marries a lady with some wealth and some money. He has an obligation to pay child maintenance. The question is, does his new spouse have an obligation to support the stepchild, his other child? The quick answer is no. There is no legal obligation upon step-parents to maintain their stepchildren. There's no legal obligation to do that. However, it does play an important factor, the marriage between the step-parents, and the step-parent, is that if they are married in community of property, maintenance gets paid from the joint estate. So if this specific questioner is married to his new wife in community of property, then the ex-wife can approach the court and say, although my ex-husband does not earn much money, his current wife earns a lot of money, and that money belongs to the joint estate, and the joint estate has a legal obligation to pay the child maintenance. So that's how it goes. And that's it, guys. I think we're now running out of time. Let's check the time out. Yes, we passed the 20, almost the 20-minute mark. I'll be having this video again tomorrow. Please, there'll be a notification today, later on today, going specifically as to what time this live webinar will take place. If you have any questions you'd like to pose, please join in and pose a question while the webinar is taking place, and we'll try our best to answer those specific questions. Thank you very much, and I'll see you tomorrow.